Okay, so today we're going to look at criminal pretrial procedures from Unit 4, Area Study 2. The study design sets out that you need to know the purpose of pretrial procedures, including bail and remand and committal hearings. So you must know bail and remand, and you must know committal hearings. I think it's also good to know some individual rights and police powers that can come under pretrial procedures as well. Just generally, the purpose of criminal pretrial procedures, they do a number of things. They assist the police to do their job. They can protect the rights of the accused. They provide rights to the police in terms of being able to ask for people's names and addresses, being able to arrest people in certain circumstances, and being able to search. They provide an opportunity for the accused to be released from custody pending their trial. They determine whether a trial should actually proceed or not. And they allow the accused to plead guilty or not guilty. Firstly, for bail and remand, the purpose of bail essentially is to allow an accused person to go free until the hearing or trial. A lot of people think that the purpose of bail is so that the person can pay a deposit of money. It's true that bail often does involve depositing money, but the actual purpose is to allow the person to go free until the hearing or trial. It upholds the presumption of innocence, that until somebody's been found guilty of an offence, they shouldn't be held in custody. Remand, the purpose of remand is essentially to protect the community against the actions of an accused person if the court believes that they may either re-offend, like commit another offence whilst they're released, whether they might inflict harm on other members of society, if they might commit further crimes, or if they think that the person might fail to appear before the court for justice to be served. So, in terms of the procedure, once the defendant has been charged, they can either be released on bail, they can be held in remand until the case comes to trial, and bail is usually granted unless there's flight risk, if they think that the person may not show up to court, if they believe that they're a danger to society, or if they're already in custody for another offence. So, as I said, bail is usually granted because people are assumed to be innocent until they're proven guilty, unless there's an overwhelming reason not to release them. If they're a flight risk, if they might commit further crimes, or if they're already in custody for another offence. It does sometimes involve a deposit of money, although not necessarily. Committal hearings. The purpose of a committal hearing is essentially to determine whether a prima facie case exists. Prima facie means at first look, so really to determine or to establish whether there is sufficient evidence to support a conviction by a jury at trial. The aim is really to avoid the time and expense of an unnecessary trial if the prosecution, if the police haven't got enough evidence for the case to go ahead, then it'll be thrown out at the committal hearings. Obviously that saves time, saves money, and it reduces the stress on the accused for not having to go through a trial unnecessarily. Committal hearings, their procedure, essentially the judge will examine the hand-up brief of evidence. The prosecution will put together all the evidence in written format generally, including all witness statements, photographs of the scene, forensic evidence that they've collected. The judge will look at that, generally in written form. They can hear oral testimony if necessary, although they try to avoid that in order to speed up the committal hearing process. And having looked at that, having looked at all of the evidence, then the judge will decide whether there's enough evidence to go to trial. So if the judge does decide that, if they decide that the prima facie case has been established, then the defendant is said to be committed to trial. They'll either be released on bail or held in remand at that point. All the evidence collected forms the depositions, and then a presentment is drawn up which contains the details of the charges against the accused. I mentioned that it's important to know individual rights and police powers. Obviously there's a whole bunch of different individual rights and police powers. I think it's important that you should know at least 2 individual rights and two police powers. If you know more, that's obviously better, but you should know at least a minimum of 2 individual rights and 2 police powers. A sample exam question from a couple of years ago was along the lines of James has just been arrested. outline one individual right he has and one police power the police have in this situation. So for this question, you couldn't use the police power of arrest because he's already been arrested. You could have used something like the police have the power to detain him for a reasonable amount of time. They have the power to ask for his name and address, or they have the power to obtain a search warrant. So it's important that you do have two individual rights and two police powers so that you just cover all possible situations. First individual right you might know is the right to silence. The right to silence ensures that the accused does not have to answer police questioning. They don't have to testify if they're committed to stand trial. It's designed to protect the accused from saying anything that may be incriminating. And the police must ensure the suspect understands their right to silence, otherwise anything they say may be inadmissible in court. The right to silence essentially protects the presumption of innocence, that you're presumed innocent until found guilty. The burden of proof is on the prosecution to prove your guilt, and you're under no obligation to assist them in proving your guilt. You also have a right to contact a lawyer. So a person has the right to communicate with a lawyer and a relative or a friend when they've been arrested, unless the police believe that it will result in the escape of an accomplice or it will result in the destruction of evidence. The suspect should be given the opportunity to meet with their lawyer in private, and they should also be able to have the lawyer present during all police questioning. Some police powers. The police have the power to arrest without a warrant if they reasonably believe that the suspect committed a crime and the arrest is necessary to preserve public safety, to prevent the continuation of the offence, and to ensure the suspect appears in court. So if all of those conditions are met, then the police can take the person into custody without obtaining an arrest warrant. Police can also search with a warrant. They can obtain a warrant to search if they believe that that search will disclose either stolen goods, evidence of a crime, goods that might be used in a crime, or any goods relevant to the commission of a crime. So we've seen previously that search warrants are generally issued by the magistrate's court, so the police could go to the magistrate with the evidence they have that they believe that the search will disclose any of those things, and if the magistrate agrees, then they will issue a search warrant. The police can go ahead. And that's it.